I don't know how many of you know about the Online Safety Act, which came into being very, very quickly in one sense, but has been talked about in Sri Lanka for a number of years, though not in the form that it was passed or rushed through Parliament. The discussions around some way and a framework to address the growth of online harms in Sri Lanka around is just like around the world has been active for a while. You can ask me questions as to how it came about, but the first hint of a regulatory framework was around late 2019. And then, of course, COVID-19 hit and everything went to the back burner. And then we had the first submission of what at the time was the Online Safety Bill around mid 2023. My first article around it expressing significant concerns was, I think, about August or September. And then early in the early part of this year, it was rushed through Parliament, and it is now an act. So it is in our statute books. And the point is, if anything, that it is unprecedented in our legal framework. It is unprecedented in the overbroad powers that it gives to those in power and government. And there's actually nothing like it, not just in Sri Lanka, but as a subject domain specialist, there's nothing like this act in comparable countries or contexts around the world, all of whom are trying to deal with online harms. But the Sri Lankan one is unique and not in a good way. You would like to be unique for being thoughtful and mindful and a law that is fit for purpose. But sadly, uh, the Sri Lankan Act or law is very far from that. So that's kind of how the the discussion about the OSA, I think, is a really important one for everybody in this country and even the diaspora, which I'll touch on later on. The president, um, early or mid May, made the statement that he's very proud that 75 laws have been passed. He wasn't entirely clear on the period, but he suggested that it was in the past 2 years, meaning that it was after the Aragale, meaning that it was after 2022, and he became executive president. This is Amanta Artikala, who's a award-winning and probably the best-known cartoonist, political cartoonist in the country. And he drew this, I think, the very next day or 2 days after that statement. And for those who can't understand Sinhala, පසුගිය වසර දෙකට නවනීති 75ක් සම්මතයි පුවතක්. So over the past 2 years, there are 75 new laws that have been passed. And Avanta, I think, really makes a really good critique as ever around the nature of these laws. Again, we don't quite know what the 75 laws are, but the OSA is one of them. And what Avanta tries to pictorially depict is the concern that a lot of these laws have been passed without the public not ever being consulted and not knowing what's in them. And leave aside the public, if you come to the OSA, actually the parliamentarians even didn't know on the eve of the parliamentary debate what was in the bill, which I'll come to and speak about later as well. So it's not really about the passage of or the passing of the laws that's a significant concern, but the qualitative nature of them and what they mean for rights, but also lives and livelihoods of ordinary citizens in this country. So I'm going to talk about the OSA in particular, but it really can't be talked about in isolation. You have to talk about, as Vanushi mentioned. I understand. I get it, right? I mean, people are really tired about hearing about human rights, and particularly in the diaspora, there might be a real interest in moving beyond that and grasping the potential of this beautiful country as we know it and not talking about rights. But we have to take the world as it is, to quote Ben Rhodes and his book on the Obama years, and not the world as it should be. And we have to take Sri Lanka as it is. And Sri Lanka as it is not in good shape. Um, There are significant concerns about human rights. The Aragaleya's clarion call for quote unquote a system change hasn't been realized. And what we see today is the politics of old giving rise to laws like this, which smack of the kind of context and human rights frameworks or the violation of those frameworks that gave rise to the Aragaleya in the first instance. The OSA itself, if you take it or talk about it in isolation, with mindful of that broader context, which gave rise to it, which gave birth to it, and within which it will be also instrumentalized and interpreted and weaponized as well, is absolutely unprecedented. There is nothing like it in the history of jurisprudence, legal frameworks, and regulatory frameworks in the country around any issue. Leave aside the regulation of online harms. Ostensibly, I should say. I shouldn't give credence to the fiction that it is about online harms, but even if you take it at face value, there's nothing like it in our statute books. The point I repeatedly have made is that this impacts everybody. And the reason I say this is because I don't know whether it's in the diaspora. I can't speak on I have very limited experience with even the NZ diaspora, but certainly in Sri Lanka, there is this tendency to kind of dismiss laws and regulations as not being applicable to us. And in Sinhala, you'll find people saying, Apita dala ne. Apita badagat ne. This is not applicable to us. This is not important to us. This doesn't impact our lives or our livelihoods. And generally that's the case because, for example, with anti-terrorism legislation, the general belief, and I think it's not unfounded, is that there are very few terrorists. And so we are not a terrorist. So why should we be concerned about anything to do with terrorism or countering terrorism? And so there's a general distance from lawmaking, policy making, because there is that perception that it doesn't really impact us. And you have to understand this also in a country where there is a enduring existential crisis. People are hungry. I don't know what the headlines are that the Sri Lankan community and the diaspora reads in New Zealand, but the global headlines and the national headlines do not accurately portray the conditions on the ground in the country. And I can say that with some authority because I'm based here. People are suffering. The impact of the Aragaleya hasn't gone away. People can still barely afford eggs or paripu or a meal, and not just bhat or not just rice, but a fulsome meal. So you can imagine that in such a country that the comparatively more academic pursuit of trying to understand the kind of thing that the OSA represents is a luxury. Many don't want to even engage with because they are more concerned about family and food. But the point is that this impacts everybody. All 21 plus million folk in the country, future generations, as long as it is in the statute books. And I would make the case today, and for the first time, because this is the first time I'm actually speaking to diaspora, that it horrendously impacts diaspora as well, particularly if any one of you have family back home, or even friends, or even colleagues, or even children. It's massive, right? I mean, so that's a big problem, and it doesn't really matter where in the world you are, and particularly if you are in the country, it impacts everybody. The point I've also tried to make is that, again, academics like myself who have subject domain expertise in this area might want to dissect this line by line, clause by clause, article by article. And you could do it. And a lot of people have done it. I've done it. But it's not really helpful because it doesn't make sense. The act itself is completely nonsensical. There's internal incoherence to a degree that you really wonder what the competency of those who drafted it are. But then you very quickly realize that if you take the logic of the act as it stands, it's not really about online harms, but it is about the entrenchment of power and the securing of incumbency. Mind you, it's not about just the incumbent, but it's the securing of incumbency, which is to say that it is to secure power by those who already wield it. And then it becomes very obvious from that perspective that the OSA is designed to help with that effort. It's not about online harms, but it is about securing power and strengthening it. And that is why I say that it is a party blind threat to democracy. Again, I stress that because, like in the diaspora, many here are, very vocal about who they support politically and who they vote for and what president they love and which president they don't love. And I'm like, yeah, that's fine. That's all good. I'm not trying to kind of change your vote. What I'm trying to suggest to you is that this act, this law, is a party blind threat. It doesn't matter who you believe in and who you vote for. As long as this is in our statute books, it is an unprecedented threat to citizenship. It is an unprecedented threat to democracy, and it will completely stunt the country's democratic realization, particularly after 2022's Aragalaya. And I will go on to suggest that it is going to really piss off, and it has, the entire global internet and social media industry, which in our position, you really don't want to do. Any country doesn't want to do that. But Sri Lanka certainly doesn't want to do that. And that is what they're risking with this law. I want to go through some I really won't go into the legal part of it because I think that goes over everybody's heads and that's not necessary either. I want to go through some top line issues, as it were. And some of these may sound quite incredible, really. I've got somewhat used to talking about this, but I think that many people, when they hear it for the first time, they think, listen, Sanjana is really exaggerating this. It can't be that bad, surely. But the strange thing is, it is. It's actually much worse that I'm going to present. I'm just going to present the top line stuff. But if you go into the real substance of it, it's unprecedented in how bad it is. The first point is that it's not, there is a concern generally that the law is about what folks will post henceforth. So if you post a comment or a post or put something up today, it's about the application of the law in the future to hold you accountable for what you posted today. The point about the law, and I made this repeatedly, is that it doesn't only have a guardrail or a boundary around what will be posted henceforth, but it is about everything that an individual has posted or commented on online from the first time that they went online. Like literally, if you started your internet engagement during the time of dial-up modems and GeoCities and email and maybe even bulletin boards, if they're currently accessible, the law or the act allows a magistrate or a particular commission under the act that can be established but hasn't yet, the power to go through your entire internet history from the first time that you connected to the internet. So it's mind-bogglingly broad and invasive, and it goes back through your entire, or potentially can go back through your entire internet history, and also in perpetuity. So it's future as well as everything in the past. The other point is, I think, somewhat glossed over when we refer to it, it's on the Online Safety Act. But many people interpret that as only social media. But it's actually online. And in that sense, that's the most truthful the act is. It's everything online. The act specifically notes that if there is an IP address, and for those who don't understand IP, an IP is like a physical location. So 40 upon 3 Hill Street, or Temple Trees, or 1 upon 2 Gall Road, right? So all our buildings, all our houses, the postal system works on addresses, and at some violence to how complex the internet is, that's also how the internet works. All our devices, whether they are a smartphone or a computer or a laptop or whatever, have a unique address. And the act determines that any device, anywhere in the world, with an IP address falls under the act. Anything that you have put up, if it is online, also falls under the Act. And that literally means Google Drive, OneDrive, photos, emails, anything that is online, anything also that is obviously on social media falls under the Act. So it could be professional to private, cloud hosting through to social media, and things that you might not generally associate with social media, like, for example, your personal backups, your photos that are on the cloud, whatever, right? I mean, you might have your file storage on the cloud. If it has an IP address, it falls under the Act. Now, is this really new for those of us who have been studying the downward slide of the freedom of expression in this country for a number of years? As Vanushi very kindly and in an extraordinarily long introduction said that I was also part of Ground Views. I founded it, and as a consequence of founding it and running it for 15 years, I also had a gaze on the human rights conditions in this country throughout the war and after the war, and in fact, before the end of the war as well. I started it in 2007. So is this really new in that sense? And I want to just raise the example of J.S. Tissanagam, Tissa, to lots of us who knew him. Tissa is alive, but not in the country. He's in exile. He'll never return to the country. He and his wife left the country around 2013. But the reason he left the country is why I want to very briefly bring it up. Tissa was a Tamil journalist, a really good Tamil journalist, like one of the few who were, towards the end of the war, reporting on the conditions on the ground, in English, by the way. Tissa had a magazine. And in 2006, July, he wrote, I'm not going to read that out. You can read it for yourself. And what I will just suggest to you is that for somebody like myself, this was not a concoction of Tissa's imagination. Tissa wasn't drunk. Tissa wasn't high on something. Tissa wasn't creating something out of a fictive, febrile imagination. What is in this editorial is true. What is up here is true. It was true in terms of bearing witness to what he saw and many others who wanted to see was happening on the ground at the time. In November the same year, Tissa wrote an article, which again, I'm not going to read out. You can read it for yourself. This again was true. And even if some were to suggest that this was not true, I would submit that what happened to Tissa is not the way of going about things. What happened to Tissa was that he was taken into, well, he was abducted, then subsequently incarcerated. He was tortured. His fingernails were pulled out. And then under duress, that confession was used along with the two pieces of writing that I showed up on the screen in a case against him. And those were the only three things that the Attorney General's Department used against him in that case, right? The two slides that I showed and the forced confession under duress. And Tissa was given 20 years of RI, right? 20 years of RI in a Sri Lankan prison kills you. You don't survive it. You can't survive it, right? This is like a gulag. And the reason that was given on the 31st of August 2009, remember this was decades prior to the OSA, was that thing that I've highlighted, that he aroused communal feelings. This is out of the judgment. The judgment and the case is on Wikipedia if you want to Google it. And that was why they said that he deserved 20 years of rigorous imprisonment. This then became a cause celeb. President Obama referred to him as a prisoner of conscience. And to cut a long story short, he was released. He was pardoned. He was released, and he left the country. The point is not about the fact that he's alive and he left the country, but I just wanted to stress what's highlighted up there, which is that for what he wrote, he got 20 years of rigorous imprisonment for arousing communal feelings. I want you to hold that as you consider what is in, this is not my language, this is a copy paste out of section or clause or clause 12 of the OSA. In the singular version, it's a different clause, but this is a copy paste from the English version of it. And it's really quite staggering in terms of the audacity and the hubris and the chutzpah of the Sri Lankan government to believe that this act applies to every person on planet Earth. Everybody. Like, this is, again, I've stressed that this is not my interpretation of it. This is language that has been copied and pasted from the act as it stands. This is in our statute books, right? This was passed in parliament. So any person, whether in or outside of Sri Lanka, anybody, anywhere in the world, falls under this law. And then you go into even more problematic terrain, which are these references to national security, public health, public order, or promotes feelings of ill will and hostility between different classes of people. Right? In Sinhala, it's even more bizarre. They actually talk about panti beda. Right? Panti. So, your guess is as good as mine if the question were to be asked of me as to what any of this means. It's meaningless in one sense, but it's pregnant with meaning in another sense, because you can define these terms as you see fit. And that's the problem. These are meaningless. It doesn't, public health is undefined. Public order is undefined. And you then see that if in 2009, Tissa was incarcerated for 20 years of rigorous imprisonment, I make the point, as I have always done since the beginning of this year, that today, all of us in Sri Lanka, we are all potentially a Tissanayaga, because all of us can be brought to book and be given a prison sentence of 5 years, as the law stands now, or a fine of 500,000 rupees at a minimum, or both, for the arbitrary definitions that are in the law that can be applied to whatever that we say, wherever, whenever. We are also now an Arundhati Roy. If you follow the case of Roy, and the fact that the Indian government has opened up a case against her for something that she wrote or spoke 14 years ago in 2010 around Kashmir, as a particular Indian law that they've used, I have made the point, including in a LinkedIn and a WordPress post that I wrote up last evening, that the OSA makes us all a Roy as well because of what I said earlier. The OSA allows the government or the magistrates or the process that can be used against you under the law to go back in time to whenever you posted anything, wherever. And if you're concerned about Roy and her fate in India, I would just encourage you to think about the fate of somebody in Sri Lanka under this law, which is no different to what Roy would face in the weeks and months ahead. So it's really quite worrying. And as I said, the fact that these words and phrases don't mean anything, they're not, feelings, I've always said half jokingly, are the stuff of, rom-coms and love letters and a billet doux that you would write to somebody that you are feverishly pursuing. Feelings have no place in the law. You can't define feelings. And in Sinhala, I don't know whether you understand, I said, this is not an adara katha, this is not a love story. You can't have feelings because you can't, how do you have jurisprudence on feelings? And so the weaponization of interpretation is actually what is the intent of the act. And with a court system that is not independent, and I might add just to broaden the scope. Today we are looking at the real problems that the Supreme Court of the United States has with regards to their independence and judicial corruption. So it's not just the third world, or it's not just a Sri Lankan problem, but the Sri Lankan courts have had significant problems with independence. under multiple executive presidents. And so the real fear is that given that context and given that history, that the act's incorporation of loose, overbroad definitions is designed so that the judiciary can interpret them as they see fit to go after anybody they want for whatever that they've published. So it's a subjective weaponization and instrumentalization. So you have these words maliciously, wantonly, false, prohibited content, and feelings. All of these, by the way, are taken out from the act. They make no sense, but they make every sense for an autocrat, an authoritarian, or an overbearing executive now and in the future, because these are words that can be used however they see fit to clamp down on dissent. You also have this bizarre creation. you know, Sometimes you have to laugh at how bizarre all of this is, but you have something called the Online Safety Commission. I've called it the Truth Commission because in the way that the act is worded, and I'm not making this up, so this is not hyperbole. The Online Truth Commission, or the Online Safety Commission, as it were, determines what is true or not. And so that's really quite interesting because what they determine to be true, independent of its veracity, under the act, is so determined to be true. So it's not just an Orwellian world that we have now entered into. It's also it's like something under Samuel Beckett or an absurdist play where you really don't know what on earth to think because you're not the arbiter of truth anymore. So I'll just make this very simple. I was talking to Namini Vijayadasa, who's the most senior and celebrated investigative journalist in Sri Lanka, and she writes regularly to the Sunday Times. So you're talking about a globally renowned investigative journalist. And she's very worried on a number of fronts, but also because whatever she writes in terms of corruption or graft, which is generally what she writes about, and is the only person to write about it and has the courage to write about it as well, now can be determined by the OSA to be false. And it's not the people that she writes about who are going to be held accountable, but it's her who's going to go up on the dock. Because you have this commission, once it is constituted, which it isn't constituted yet, that has the power to determine what is true or not. You also have, as you can imagine, a hellish impact on minorities. And by the way, because I'm in Sri Lanka, because I've spoken to hundreds of people from January onwards, largely my engagements are in Sinhala, because it's actually why I love to speak in Sinhala because I like to be a bridge between the kind of discourse that's only in English and to help folks who can't grasp English deal with the consequences of this draconian law. And I must say very, very clearly that the Tamils in the north and the east, from the day the act was passed, if you pardon the language and permit me to use this, are shitting bricks. Because the only space that they had for memorialization or for critical commentary or for political discussions or anything questioning the state and narratives and history and their future and their past was online. And now that's gone. And they are very worried and they are very concerned. And they're really very sad. And so this is going to have an asymmetrical impact on minorities, including the GLBTIQA plus community, religious minorities, and any other minorities in the country. And the reason I put Kanji at the background is that it's a really interesting case. I'm sure most of you in the diaspora won't know about it, but towards the memorialization, towards the 19th of May, when the two communities in Sri Lanka memorialized the end of the war in very different ways, the Tamils, I'm sure you know what kanji is. It's rice porridge, right? I mean, it's sort of like kiribat, but it's much better, I think. But, they tried to, the kanji has become a symbol of memorialization and the family and the individual's family is lost, right? And the government took out a court order banning the production of kanji and arresting people who distributed kanji, which is like, it just blows your mind around the absurdity and the violence of it. But the point I make is not just that. Today, if I were to talk about that, and if I were to put up a photo of the arrest or the videos that actually did go up around how brutal the police were when they went after the people who were making the kanji, that itself is a greater violation under the OSA. So it's not just the kanji production physically, but it's the representation digitally of the kanji production and its distribution that can hold people who bear witness to what is going on the ground accountable under the OSA, and in ways that are no different to the penal code or whatever that the police use to arrest the people who are actually producing kanji. So it's actually quite bizarre. It really does your head in to understand the implications of this act on even bearing witness to what is going on in the country. And I want to stress that because I know that a lot of us have photo archives, right? Photos and videos. We have it on Google Cloud. We have it maybe on some kind of cloud service, cloud platform. And many of us, actually, many Tamils, many in the country, and remember, this act applies to anybody, anywhere in the world, including in the diaspora, many have really sensitive content that we have records of. What happened to us, what happened to our families, why we left Sri Lanka, how we were tortured, the perpetrators of torture. If those archives now are put online, they are subject to the OSA. And that is why I say the personal can be interpreted as politically violative under the Act. I have been talking with the National Archives of Sri Lanka. The National Archives director is a wonderful person, remarkable Sri Lankan. And they have had to go to the Attorney General's department to get a special exemption from the OSA so as to not conflict with the law and what the National Archives is constituted under. By the way, I don't want to get too technical, but we are in the throes of actually debating a new Records Management and National Archives Act as well. So that's a discussion that's happening. But they had to go to the Attorney General's department to get a special exemption because the act would impede and impinge on the National Archives and the kind of content that they have, which may be determined to be arousing communal feelings or going against somebody's feelings or going against a class of people. So you have these absurd things that have arisen as a consequence of the OSA. The commission that has not been constituted yet falls under the Constitutional Commission, which falls under the executive. The problem here is that Mr. Ranil Wickremesinghe, who is the current incumbent president, said a very disturbing thing about 3 months ago, where he explicitly said that the Constitutional Council is an extension of the executive president or the presidency. He didn't necessarily mean himself. He meant the office of the executive president, which is hugely problematic because it's not supposed to be that. Actually, it isn't that. But if you take that interpretation for face value, it means that essentially the experts who are going to be part of the commission are going to be subject to the authority of and the whims and fancies and fiat of the incumbent president and any president who comes thereafter. So essentially, even though it appears to be that the commission is independent, it's actually not. These experts have unbridled authority to go into your devices. In fact, the act doesn't give any recourse for appeal. I'm going to say that again, because I know Vanushi is the most legally trained amongst, I suppose, this audience. The act has no recourse to appeal if an expert determined by the commission decides that you are in violation of the act and you have to hand over all your devices and all your pass keys in order for the commission to get into your personal and maybe even professional accounts in order to kind of investigate how you have contravened the act. So It's really quite extraordinary, the degree to which they can get into your lives and mess around. All of this is with a view to stopping the kind of narratives that we saw gave rise to the Aragale. And then the penny drops. This is entirely about the suppression of dissent. I want to make very clear what I see the Aragalaya as, because I think the Aragalaya means different things to different people. I really studied it, right? I mean, I've written about it, I've talked about it, I've given lectures at Otago, I've given lectures in Sri Lanka. So there's a lot that I did at the time and since. And I saw the Aragalaya as a collection of critical narratives, an extraordinary, unprecedented moment and movement in Sri Lanka where offline and online narratives that bound people in their sadness, anger, fear, anxiety, and disgust propelled a movement that essentially saw the then executive president leave office. The current government and maybe even the current president are very, 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 very scared of that happening again. And so maybe most of the politicians who are still in parliament from that government to the current government. And so what they want to do through the OSA is to stop completely that from happening again. And the act is very good because I can't imagine the Aragalaya or anything remotely approximating the Aragalaya ever occurring again in the future were, God forbid, the country were to face a crisis like that in the future, ever happening under the OSA. It gives rise to increased surveillance in a country that already has really invasive, pervasive surveillance architectures, because the act determines that intermediaries and internet service providers keep a record of what is communicated online, or on demand and on request are able to provide that record to the courts or the commission, which means that it is harvesting data at scale. I mean, I don't want to go into Cambridge Analytica. I don't want to go into why this is a problem. It is a huge problem even in the West. I've talked about it in the context of Aotearoa New Zealand as well. So it is a problem hitting NZ as well. But I just want to make the point that I have put under that main heading there, which is a law called the Personal Data Protection Act, the PDPA. This was supported by the European Union. And I know that Sri Lanka can be proud of very few things, genuinely, apart from maybe the cricket when it shines, and that also seems to be eluding us of late. But the PDPA is a gold standard in lawmaking in terms of personal data protection. It really is a very, very good law. And it went through the motions of being consultative. And we have that in our statute books right now. The problem is that the OSA is at complete and utter odds with the PDPA. There is no coherence at all. And no lawyer I've spoken to since January has been able to figure out how this can be reconciled. Because you cannot. It's irreconcilable. And that's also a huge problem because of the fact that the OSA wants to harvest this data at scale, and the PDPA expressly forbids it. Nobody in the country I know knows quite how to comply. But you have to comply. If you're a institution, you have to try to figure out how you can be in compliance with the law, but nobody knows how to do it, which means that people are really anxious, people are really scared, people are really fearful, and they don't want to be caught in violation of the act, but neither can they figure out how they can protect themselves from that, because as I said, you can't protect yourself from the arbitrary nature of the very act. So it's a really bizarre situation where people want to be perhaps conscientious and make sure that they're not violating the law, but you can't, because the law makes no sense. It's already resulted, as I said, in Tamils not saying things now, not putting up things already from the day that this law was passed in Parliament. And that's going to get worse. I can tell you that investigative journalists are also very worried. Activists are very worried. Advocacy is being stifled. And I always make the point, including this video, including all of what I've said, wherever I've said it, that has gone up online, I can be held accountable. Anybody can. For whatever that can be determined as something that I said by whoever, that it aroused communal feelings or hurt somebody's feelings or created a class divide or in some way, shape, or form was violative of the act. And I say, as I say, and I keep saying, this is perpetual, invasive, and pervasive. So this is the one slide that I just want you to reflect on. And I say, and that's why I also said that I'm going to share this slide deck. It's a lot to take in, but I wanted to capture just how broadly felt this law is. And people don't realize it. Whatever that you do, whoever that you are, wherever that you are, however that you engage with content online, you're impacted. And it's not just that. It's wherever you are in the world, whether you're in the diaspora or whoever you are in the world, the act impacts you. And the sordid history of this country, sadly, is that the worst interpretation of the law is what is going to be the norm. Now, is the threat recognized? And I'll very quickly say, and you can ask me questions about it. I've talked to literally hundreds of people, trade unions, teachers, academics, Tamils, Muslims, Sinhalese, the clergy, the Buddhist Sangha. Nobody understands it. Not one. Lawyers, high net worth individuals, really, really rich people, really good business people, famous people, marketers, advertisers, politicians. I can tell you a story. On the eve of the parliamentary debate, it was a Monday. There was a closed door workshop by a leading NGO that I went to. I had just returned to Sri Lanka, and all of the opposition parliamentarians who were present, all of them at the workshop, came up to me and said, "Sanjana, can you please help us make our floor speeches for the next day's debate? Because we didn't realize this was that bad till you spoke and mentioned what you did." I gave a scathing critique of the bill, and all of the opposition parliamentarians wanted help. In fact, for those of you who follow me, that is my pinned tweet. My pinned tweet, it's a private account now. I can send you that Google Doc. It's a Google Doc that I sent to the parliamentarians with some tips and guidance and critiques that they could use in Parliament. So nobody from parliamentarians outwards or downwards in the country understands how bad this is. But reflecting on what Suin and Ranjit and also Vanushi wanted me to talk about, and as I said, this is the first time I'm talking about this because it's the first time I'm talking to a Sri Lankan diaspora anywhere in the world. So it's really nice actually to be engaging with a country that is my second home and the Sri Lankans there as well. Is this threat recognized by diaspora? I don't think so. I don't know. And I would hazard a guess that you have no clue as to how bad the OSA alone is and its hurried passage through Parliament early this year. And I want to ground this very specifically in New Zealand. You have really good legal, regulatory, and in a sense, constitutional protections around privacy. And again, I differ to Vanushi, who's the expert on this, but just a layperson's reading suggests that the OSA is in complete violation of the Privacy Act of 2020. There's a specific thing called information protection provisions. It's in violation of nearly all of them. That matters, right? Because the act, as I said, not just applies to Sri Lankans, and not just to diaspora, but it applies to New Zealanders of Sri Lankan descent who are New Zealanders and dual citizens. So, this is new terrain for bilateral relations as to how the weaponization of the act that is extraterritorial, that will extend to New Zealand's citizenry, will play out. it is almost in complete contravention and opposition to the Bill of Rights and what is guaranteed to New Zealanders as a consequence of the 1990 law. So I'm not going to read that out, but if you compare the OSA with what is guaranteed to New Zealanders under the Bill of Rights, it's diametrically opposed. It's irreconcilably opposed. It encroaches on the rights that are protected under the Bill of Rights in New Zealand. So again, I really don't know how this is going to play out. If there were to be a case brought against a dual citizen, a member of the diaspora, or even a New Zealander. So there are a couple of points there in relation to both the Privacy Act and also the Bill of Rights. There's this overbroad definition of false statements, which is repeatedly mentioned in the Act. Is completely going against what is a more well-defined definition and rights that are guaranteed by applicable laws in New Zealand. It's really worrying for diaspora members who might actually still visit Sri Lanka. And I'll stress this later on, it's even worrying for the conversations that you'll have within a friend network or a family network on Sri Lanka. And I just want you to think about, for example, many of you would have been involved in the Aragalaya discussions, maybe not supporting it, maybe supporting it, but certainly engaging with it. All of that content is now up for grabs under the OSA. And if you made any kind of public post or commentary, all of that is up for grabs as well. And, it's not a great leap of imagination to think about visa processes and immigration systems and networks being connected to the kind of surveillance architectures that are enabled by the OSA, and then you can see where this is going. There are very, very harsh penalties that, as I said, prison sentences and very, very high fines around arbitrary definitions of what's in the Act. The Sri Lankan government, this government, future governments may target members of the families that you have here or still remain here because you might be more courageous in what you say and put out and comment on and seek to uphold and want to bring about. But like in other countries, and I won't name them, but we know these countries, they go after the members of the family who remain in the country, and the OSA loves that. So this is very worrying in that sense as well. It can lead to massive surveillance around not just those in the country, but those they are connected to, which means diaspora communities as well. And as I said, the law makes no distinction between professional and private communications. It can technically get into on request, on demand, your WhatsApp exchanges and messages, your Signal messages and what have you, right? Even your emails, by the way. And I think this is, you need to get your head around this. The OSA allows the OSA gives the power to block any site or any address with an IP address. So any app, service, platform, network with an IP address can be temporarily or permanently blocked by the powers in the OSA. This means, just to put it very simply, that the OSA can say arbitrarily that Facebook is arousing communal feelings, so we are not going to allow it. Or Facebook Messenger, or Instagram, or a particular account on Instagram, right? So it can get very granular and detailed, or it can be very broad in terms of an entire platform. But if that were to happen, that can very seriously impact your ability to keep in touch with people back home, back in Sri Lanka, right? So this is, again, not science fiction. This is what the law allows. And, I think you should be worried, frankly. And I'm going to be very, very frank. The manner in which, if any one of you have family here, the manner in which there is a risk now. I'm not saying it's guaranteed to happen. But if any one of you were to take a stance that is deemed to be inconvenient by whoever, for whatever reason, whenever, and whenever that you posted, whatever that you posted, wherever, it can be very serious for the folk back here. Yeah. And obviously, a country that is already really reeling from the implosion in 2022, this means chilling effects because of the fear of losing one's livelihoods as well. So that's what I said, the chilling effects are going to be very real. It's not a forward projection. It's not a future projection. And the chilling effects will extend to the diaspora, right? You will also now have to, in a sense, be mindful that there is this law in the country that is extraterritorial in nature and can impact what you say and do, even in Aotearoa, New Zealand. You need to see this. I mean, I coming to the end. You need to see this as a repressive scaffolding, is what I've called it. This is not the only law that the government is proposing. Um, there are at least three other drafts that are very worrying, and it's not just me saying it. It's experts in the media who are saying it. People like Professor Rohan Samarajiva, people who are leading academics and researchers at institutions like LearnAsia, who do deal with and are leading thinkers around internet regulation and telecoms regulation, cybersecurity experts, and human rights activists around the Anti-Terrorism Act draft. They are all very worried about the direction all of this is going, because all of it is falling under the Ministry of Defense and none of it is actually in the public domain. I'm not making that up. Like, you don't know what these drafts are because it's not in the public domain. The MPs don't know. And in as much as what is in the public domain, it's all being controlled by the Ministry of Defense. It's really quite horrific because Clause 65 of the Anti-Terrorism Act, which is different to the OSA, just to be very clear, but I'm talking about the general scaffolding of repression that's coming about through the enactment of laws. Clause 65 orders companies like Meta to give up encryption. Orders it. This is why there is an active case in the Delhi High Court in India that is going to be heard next month, which Meta has said will determine whether they keep WhatsApp in the country or not. India is Meta's largest market for WhatsApp. There are, I think, about over 600 million users of WhatsApp. It's central to Prime Minister Modi and the BJP's political machinations and propaganda. It's their largest market, and they have said that they will pull out because of the Indian government's edict that the encryption keys need to be handed over because of a 2021 law that India has. Sri Lanka's draft Anti-Terrorism Act's Clause 65 has the same thing. So my point is that we can be proud Sri Lankans, but we have a market that's less than the population of Mumbai. So if you think Meta is going to leave India, what do you think they're going to do with us? If this is the quality of the laws that we are contemplating seriously bringing about, in addition to the Democlean, draconian debacle that is the OSA, right? So that's what I talked about, Clause 65. I just make it very simple. It's unfixable. This is there's no need to get into academic, discussions and really legal definitions and what have you. The OSA is unfixable. It cannot be fixed. It must be rejected and repealed. And that is a very simple request I've made with anybody who has chosen to listen to me, including political parties, because I have wanted it to be a key platform manifesto promise leading up to the presidential election. And that has been a key ask that I have asked that needs to be up there. I'll end by saying that lots of people think that, but I don't know what their level of awareness of this group is, but the Supreme Court, when they were examining the bill, came up with a very high number of recommendations in terms of amendments. I have been of the position that even with the incorporation of those amendments, the law is still unworkable. It must be rejected. But I am not a lawyer. So it's very, very helpful that one of the country's most senior human rights lawyers and most renowned activists, um, Dr. Satkunanathan, wrote this in March, saying that, in her opinion, that even if the Supreme Court's amendments were completely incorporated into the act, it would still be unworkable. So you are dealing with an act that is completely unworkable. And that is the law that we have in our statute books. And even the amendments that have been proposed, by the way, none of us have quite seen this, right? So I was shown something in February because Namini Vijayadasa wrote this article in the Sunday Times. She sent me the amendments. I was about 3 weeks ago sent another document with amendments that have again gone to the government. It's not in the public domain. Nobody really quite knows what the amendments really are going to be, but we have been promised amendments. But the point is, the amendments themselves don't really fix the act. It can't be fixed by amendments, even though they may come about, and for reasons that you can ask me about later on. But the amendments are not going to fix the act. The act must be rejected. The act must be repealed. It is nightmarish. And it is not just nightmarish for us. I would submit that as a consequence of this wonderful opportunity to speak with all of you in the diaspora and also New Zealanders writ large, it has really significant implications for you guys, and those you love, wherever they are, and particularly if they reside in Sri Lanka. So, kia ora, stuti. That brings me to the end of my presentation. I'm going to stop the screen share, and I'm also going to stop the recording so that we can have hopefully some discussion